don't need to offer any comments here. You don't need to offer any comments.
What happened was, Malad, this is a corporation which gives liquor outlets, Malad. And we found, Malad, that some of these people to whom the outlets have been given are actually taking cash and all that stuff. So, Malad, the state itself filed 41 FIRs from 2017 to 2021. Actually, 14 to 2021. And the ED, and against individuals, not against the corporation. The ED comes into the picture in 2025 and raids the corporation in the head office. Yes. All phones taken, everything taken, Mullahs. Everything cloned.
It's a notice. So how can an office against a corporation? No, you may register against the individuals.
That's correct.
Against a corporation, a criminal matter. So this is your ED is crossing all limits, Mr. Raju. Your ED is crossing all limits. Issue notice, returnable, file your reply. Returnable,
second matter, Lord.
Returnable after vacation. In the meantime, there shall be stay to the proceedings.
Yes.
Stays.
Take away all the phones.
I mean, the data can't be used, and the data can't be used. Your Lordship, they've held that in. Yes.
In the meantime, there shall be stay of further proceedings. Then query the petitioners.
The data can't be used. They've taken our data, Mullahs. Your Lordship, they've all our hard drives, everything.
Department files everything. Not involuntarily taken. Panchnama says for 12 hours, for 2 days, below all the phones. All the employees' phones are closed. There is something called privacy law. How can you take away?
And Lordship, they've granted stay in proceedings.
Stay in 5 matters.
5 matters.
This violation of individual. Give your phone, we'll clone your phone. We'll take all data.
We have already granted.
No, in other matters, not in this.
No, here we are granting stay.
But they will use it. Stay is only in the proceedings, Mullahs. But if they use the phone, Mullahs.
Who's belout the data which they
They've
have
got-
No.
from every employee.
That's right.
How can
We have found a fraud of 1,000 crores given to politicians.
privacy?
We have protected you. What more protection we can't grant you more than what you have prayed for. We have stayed the proceedings.
We have attached copies of these orders also, Mullahs. Of the existing stays, Mullahs.
At page 3.
Not 298 and 302, Mullahs. Yes. Those 2 orders are there already before your Lordships. Not to access, yes.
There are 4, 5 orders.
There are other orders, but we've just mentioned 2, Mullahs. 298 and 302.
Subsequently, courts have not granted in the batch, my lords.
But the point is, this is an issue of privacy. Yes, exactly.
But
They are
they-
investigating. They are ED. They should be investigating matters. This is ED, Mullahs.
But we have done nothing wrong, but I may only point out. My lords, pay the petitioners, my lord.
No, pray clause B. When they have already registered the FIRs against the officers, when they are taking actions against them, why should ED unnecessarily, and where is the predicate offense?
1,000 crores fraud has been.
This is all.
We will consider it after 2 years.
But cash has been generated. I'll point out, but let me put an affidavit, my lord.
So you put on an affidavit, we are giving notice.
You put as an investigation into a big fraud, my lord. With humble
Thank you.
request, my lord. My lords may consider, but where the petition, but they can't hold praise for others, my lord.
They are already, FIRs are registered against their officers.
FIRs are registered and the manner in which those investigations
produce
are
the
going on.
ECIR, they don't give us the ECIR,
Manner in
nothing.
which those investigations are
I am
going on by
responsible
volunteer
for my
FIRs,
employees.
that the politicians are involved, the politicians are being protected. No, it's not Malafide, my lord.
After 7 years
I'm
for
not-
doing it. there is some reason.
Next matter. You are totally violating the federal structure of the
So,
constitution.
my lord, in this case, I'll
The
demonstrate.
ED is crossing all limits.
No, it's not so in this case, but I'll demonstrate.
this case,
Maybe
in other
particular
cases it
case,
is.
but Not in this case, but I will point out, my lord. But off the
We'll
cuff,
hear it after.
off the cuff,
We'll hear it after you file your reply.
but they say hash value is not a good, everything is false.
Oh, I see.
I'll point out.
So Raju, we have already passed the orders.
But I must in all fairness state, Lords, that in January of this year, I was before this honorable court. This is an examination scam matter, Lords. Your Lordships had at that point in time given me the liberty to withdraw and to come back after a year. Now, Lords, the circumstances under which I am before this honorable court are now very different. Lords, I have a lumbar decompression surgery, which has been prescribed. If your Lordships may kindly have that document at page 76. The government, Lords, hospital says that you get that surgery done. And the reason is this, that there is disc degeneration, etc., which is minor. The compression is causing loss of sensation, tingling, numbness, etc. in my arms, and I'm in terrible pain. I'm only asking at this stage one little factor, that your Lordships may direct me to be examined by the government hospital or a specialized private hospital at this stage, and then after that consider my application for bail. One important factor that I want to place before your Lordships is this, very, very crucial. Trial has been stayed, 18 months I'm inside. Whatever conditions your Lordships impose, my Lords, removing me from the state, whatever. I'm not a good person, my Lords. I've indulged in the scam and all that, my Lords. I understand. Today, my Lords, stay at page, your Lordships will see at page 81. Please have that for a moment, my Lords, page 81. 3 separate proceedings, paragraphs 18, 19, and 20. There is a stay of the proceedings. And my Lords, please see the number of witnesses in this case, 137 witnesses. 137 witnesses, 18 months. And my Lords, everybody else has been granted bail. 4 people are absconding. Whatever conditions your Lordships are going to impose, my Lords, I'm going to bow down to that. My Lords, including, my Lords, removing me from the state, whatever directions your Lordships want, my Lords, today.
Medical college in Kalburgi.
My Lords, there is one. My Lords,
It's a big place.
I'm sorry, my Lords.
It's a big place.
My Lords, it's a big place. I've had that. Please just see for 1 second, page 76. My Lords, the Gulbarga Hospital. My Lords, if your Lordships will see, this is the letter of the medical officer of the central prison itself at page 76. The central prison hospital writing, my Lords, to the prison superintendent. This is 23rd of January. This says that pertaining to the above subject in reference to so-and-so, so-and-so. I'm sorry. About the so-and-so referred to Gulbarga Institute of so-and-so, so-and-so for complaint of pain in the backside of neck radiating to upper limb. The concerned neurosurgeon is examined and evaluated and diagnosed. So this very hospital that your Lordships are referring to.
We direct the petitioner to be produced before the director of Gulbarga Institute of Medical Sciences and Hospital, Kalburgi, shall constitute a panel of experts to examine the petitioner's medical condition and submit a report to this board.
Very grateful.
The same shall be done within a period of 2 weeks from.
I'm very grateful.
Issue notice. You go to Sir Standing Council over.
That's the sir. I'm very deeply obliged. Extremely grateful.
Yes, my Lord. This is a bail matter. Petitioner is behind the bar since more than 3 years. He has no antecedents. My Lord had granted liberty. On page 101 is the order. 103, my Lord. Order dated 18th November 2024, where my Lord had granted liberty to renew his request for bail within a period of 6 months in this court. Now, my Lord, trial has not commenced in the last 6 months. All the Roznamas have been annexed, which shows that it is at the stage of awaiting Muddamal in 6 months. The President Petitioner's advocate is always present. In fact, if my Lord will see, the date of adjournments being granted are more than 20 days between each date of hearing, which is against the procedural rule of adjournments in custody matters. And there are about more than 32 witnesses. And my Lord, in this case, even if trial has not commenced also, my Lord, and petitioner is also never produced in the court. And my Lord, one pertinent point is, my Lord, statement of the witnesses also show that he was not armed with a weapon when he went to have a conversation in the first instance.
Notice. Issue notice. Available 3 weeks.
Obliged, my Lord.
Please, my lord. Because we are students, of BAMS in the second year. Now we went to the High Court division bench only. My writ petition is pending. We are NET qualified. Counseling, my lords, the KEA, Karnataka Educational Authority, was to do 4 rounds. I'll show. They do only 2. The college admits us. We were registered duly, NET qualified. And now the division bench grants us permission to appear in first year. Now we are in the second year. Now at this stage, the Honorable Division Bench dismisses the writ petition. My lord, may kindly have just 1 page. My lord, if they don't do the 2 counseling, what is the college supposed to do? 100 seats sanctioned. Only 56 seats they were able to fill up. My lord, may kindly have their own obligation, and then there is an agreement between. Sorry.
But I'm on caveat minutes, appearing on caveat minutes for NCISM minutes, the respondent here.
File your reply.
I'll file my reply minutes.
We are praying for interim because otherwise the exams will start around 15 July. We are saying without, Lordship may clarify, no.
We are keeping it before that. We are keeping it in 3 weeks.
I didn't hear that. I'm
We are
sorry.
keeping it after 3 weeks.
After 3 weeks.
Yes.
All right.
That will be much before 15 July.
My lords.
File your reply.
I'll file my.
Or my lords. I'm obliged.
Please, Milords. Milords, I am here because there's a interim issued by the Honorable Court in a similar matter. This is
Back, the notice back.
thank you. Grateful, Milords. Milords, interim.
Same order.
Interim. Thank you. Milords, this is also for item number 41.
Okay.
Grateful, Milords.
May it please your lordships.
You already resolved the judgment in this
My
matter.
lord, reserve the judgment. Your lordship granted interim relief to my wife, my lord. I am the father of that, my lord, child who was driving at that time. I spent more than a year in custody, my lord.
This is a good model happened. First come with a application for application of
My
a
lord,
and say
in
that
fact,
you know,
it was
therefore
not even
it-
my blood sample. which was
therefore
found.
entitled to special protection under 437 and then the husband comes.
My lord, I have nowhere now to go since, my lord, there is a 3-judge bench in the High Court would hear the matter. I have nowhere to go.
No, we have resolved it.
I know, my lord, so that's over, my lord, before the High Court virtually. So, my lord, we are only awaiting. I have spent, my lord, since 21st May 24, I'm inside.
Only 1 year.
1 year, my lord, they allow me interim bail, only that, my lord. No other case against me except these lines,
Dismissed.
my lord.
Yes. 41 connect. So we are not in time.
So, my lord,
The lordships will be taking up later.
my lord, then, my lord, I'll have.
Not to withdraw.
Please, of course, my lord, I don't want a dismissal. I have nowhere to, I'll go to the High Court, my lord. Avail my remedy before the High Court. Withdraw before, to go before the High Court.
Liberty to take such steps as permissible in law.
Please, my lord.
So over here.
Please. Lord, only one thing, my lord, before the matter, my lord, the learned, my lord, solicitor begins, my lord. I had, my lord, in my own name, my lord, filed a writ petition in this court, my lord, regarding, my lord, 41A, my lord. Lord, some orders have been passed. I wish to bring to your lordship's kind notice. 41A. Which is, my lord, the duty, my lord, of the union and the states, my lord, to complete the survey within a period of 1 year's time. When did you file? This, my lord, this petition was filed in 2019. Notice issued, union appeared, all the.
That's a different issue.
No, my lord, interpretation of 41A today, my lord, has been deleted from the statutes, my lord. The process was, my lord, of a survey commissioner coming in and completing the survey within a period of 1 year. There are other ancillary issues, my lord, which are not the subject matter before this court. So my submission today before your lordship is this, my lord, that had the Union of India and the states completed the survey as directed by an amending act of 2013 within the period of 1 year, which was granted, nothing of this sort would have accrued, my lord. Today, my lord, an attempt is being made to portray the Mutawalli in some sort of a light, my lord. But the corresponding duty of the state, my lord, has miserably failed. And the other states, my lord, are all on record to say that unfortunately, we cannot start the survey for lack of manpower. For
The record, which, my lord, I do not know which
No, one
matter
second.
is referring to.
Because the state has appeared, Mr. Nathraj has appeared in this matter. With great difficulty, my lord.
I can't respond oral arguments on a matter which
No,
is
that
not.
is why, my lord,
listed. I, my lord,
the entire record.
They have already heard.
I'm
Mr.
not
Sibal,
saying that.
Mr.
I'm
Gavai
saying,
and
Lord, what I'm
Dr.
saying.
Singhvi. So, he is responding to them, and we don't have understand of these practices that in the midst of a argument, somebody rises and.
No. What I'm saying,
starts
my lord, is that
something.
the entire petition has been directed, the direction was given on me to make a mention before this court, my lord. And the batch of,
Direction has been given by whom?
by my lord, Justice Sundaresh, my lord, which was by an order dated 20th of, just 28th of April 2025. And the order reads, my lord, it's the last page of your lordship's compilation I've given. And the entire proceedings are now before this court, my lord.
No, we will be only.
So, your lordship, I would be referring to that, my lord, only for one purpose, is that the union as well as the states have miserably failed, my lord, to complete the survey.
But lord, 4 is
We are
not under
only
challenge
concerned
here.
today.
So, 4 is
As to
under
whether-
my petition, 4-1.
We are only concerned here as to whether the provisions of the act which are included in the petition should be stayed or not.
No, that's a
Correct, correct.
limited
I'm-
thing, lord.
What I'm saying is, my lord, that the documents are here, there would be a reference to 1 or 2 papers.
Yes, proceed, Mr. Tushar Mehta.
Yes, well, I'll conclude, my lord, in 10 minutes. Lord, first, lord, very fact that your lordships are required to invest 3 full days on both sides, my lord, shows that there is nothing ex officio unconstitutional which requires to be stayed by an interim order. Lord, that is my first respectful submission. Now come to, my lord.
First and best.
Yeah, yes. Yeah. You know, because the ex officio means your lordship reads and your lordship feels that no, this cannot remain on the statute book even till we decide it finally. There would be arguments, counter arguments on, for example, essential religious practices. I have filed my host of judgments. I have not read. There may be some arguments, my lord, what is essential religious practice, what is not. It would be an arguable case. And it is not, my lord, difficult, my lord, for anyone to raise arguments on both sides of the proposition. But merely because it is arguable does not mean that it deserves staying of a validly enacted statute by the competent legislature. Lord, I have prepared the note. It contains only law, no facts, with regard to the sections which were argued for the first time, and other than the 3. Lord, I'm not reading it. I'm just, my lord, taking your lordship through it, my lord. 3E, I have already pointed out, my lord, this is for the purpose of protecting the scheduled tribes and their lands. So kindly have a look at, my lord. I'm not reading the judgments, but I have placed judgments on record that this is a classification made by the Constitution itself. Scheduled tribes in scheduled areas is a class by themselves and constitutionally protected class, and therefore, my lord, there are judgments, my lord, which I have cited. Your lordships may not be troubled, my lord, by me to read these judgments, but the sum and substance of the judgment is statutes which were challenged. That why giving special treatment or a different treatment to scheduled tribes? And the court has upheld it, that it's a reasonable classification with some nexus, and the nexus is to be found in the Constitution.
Restoration of lands to the scheduled caste and scheduled tribes.
Yes, my lord, it cannot be, my lord,
But then, here, what is the nexus of not making the applications of the act applicable to the lands belonging to scheduled tribes?
yes, my lord, because scheduled tribes, my lord, the JPC, my lord, note, I have kindly see, my
Well,
lord.
the purpose under those enactments
Hmm.
was that if the person belonging to SC and ST, the lands were grabbed, taking advantage of their social and economic backwardness,
Correct, my lords.
then the land should be restored to them.
Correct, my lords.
So that those acts have been upheld,
Correct. They are upheld.
they are upheld.
Yes.
But here, that's not so. The lands are with them.
No, not with them. Well, that is the difficulty. My lord, the Waqf means a permanent dedication to the Almighty. It goes forever. My lord, I can understand if there is a intra-party transaction, I am a scheduled tribe person, my learned senior is not a scheduled tribe person, I sell the land to him, and if it is challenged that scheduled tribe person was cheated, your lordships can put the clock back and that transaction can be voided. But this would be a permanent dedication. For the purpose of interim order, if this is found to be unconstitutional, your lordships will quash it. But suppose in the meanwhile, there is a Waqf already created, it would be irreversible situation. We are, my lord, therefore addressing your lordships only on the question of interim order. The JPC has said that scheduled tribe people of scheduled areas, though they follow Islam, they have their own cultural identities separate from Islam. They do not follow Islam as understood in rest of the country. And therefore, with a view to ensure that cultural identity, my lord, this provision is made. But, my lord, it is so egregious, my lord.
It doesn't appear to be correct, in fact. Islam is Islam. Traditions, they may have different, but
Yes.
religion will remain the same.
The purpose is, my lord, why not all scheduled tribes? Scheduled tribes classified under the constitution as requiring separate protection. My lord, I can assure.
Your argument, as you have argued and you have projected, that someone had by fraud or maybe misreading or misrepresentation taken a land from the tribal and had created a Waqf. Therefore, the mere existence of the Waqf is through an illegal means. If that is void, the whole thing goes. So there is no need for such a protection. That in it itself will go.
Lord, question is, Lord, would that be a ground enough? There would be arguments and counter arguments. My lord, I may read judgments. My lord, let me read judgments. My lord, if your lordships are prima facie, my lord, satisfied, that I am only, my lord, suggesting that would that be a ground enough to stay a statutory enactment? Particularly when I am repeatedly saying that I am never given an opportunity to file a reply to this. I could have filed, my lord, statistics, reasons, figures, etc., etc. But it was identified at 3 and the court said, you filed a reply within a week. Please come to, my lord, my note. I'll just, my lord, show the what the Supreme Court has said about scheduled tribe areas in schedule. Is not, my lord, religion based. Please kindly see the provision first. Notwithstanding anything contained in this act or any other law for the time being in force, no land belonging to members of scheduled tribes, not all scheduled, I have quoted in my note. The first page quotes, for your lordship's ready reference. Notwithstanding anything contained in this act or any other law for the time being in force, no land belonging to members of scheduled tribes under the provisions of the 5th schedule or 6th schedule to the Constitution shall be declared or deemed to be Waqf property. Lord, this does not take away their right to dispose of the property. Even if they want to do charity, they can always create a trust. That is what, my lord, proviso to section 2 now provides, that if you don't wish to create a Waqf, you create a trust. Now, my lord, please see how, my lord, the Supreme Court has dealt with this proposition. My lord, the second page of this note, my lord. And I'll read, my lord, only the highlighted part. This is 2004, volume 10, SCC 65. Your lordship gets, my lord, the Chief Justice gets. The Constitution of India and the laws made thereunder treat tribals and tribal areas separately wherever needed. The tribals need to be settled, need to be taken care of by the protective arm of law and be saved from falling prey to unscrupulous device so that they may prosper and by an evolutionary process join the mainstream of the society. The process would be slow, yet it has to be initiated and kept moving. The object sought to be achieved by 1950 Act and 1956 regulations is to see that a member of an aboriginal tribe indefatigably continues to own the property which he acquires, and every process known to law by which title in immovable property is extinguished in one person to vest in another person should remain so confined in its operation in relation to tribals that the immovable property of one tribal may come to vest in another tribal, but the title of the so and so. Lord, kindly see the next judgment, my lord. In P. Rama Reddy versus State of Andhra Pradesh, this honorable court was considering the constitutional validity of a law made by legislature of Andhra Pradesh. Transfer of property, Lord, then this is the section which is quoted, and please come to para 12 of the judgment. What has emerged from the additional counter affidavit, my lord, I may skip that, my lord. Kindly come to the next page, my lord. Para 14. It cannot therefore be gains their economic and educational interest, but they also require to be immunized from social justice and exploitation. The founding fathers of the Constitution of India have in their wisdom and foresight taken cognizance of this vital aspect, as is evidenced by the provisions of Article 15.4. 15.4 is nothing in this article shall prevent the state from making any special provision for the advancement of socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. Under Article 46, promotion of educational and economic interest of scheduled caste, scheduled tribes and other weaker sections, the state shall promote with special care, etc. Then number 15, the constitutional mandate reflected in the aforesaid articles has influenced this court in no small measures in upholding the constitutionality of the impugned legislative provisions enacted with an eye on preserving and protecting the interest of tribals in the lands in the tribal areas. Lord, I'm another, my lord, way of assisting your lordship is this. After final hearing, if your lordship, my lord, still come to the conclusion that this may not muster your lordship scrutiny under Article 14 or whatever, your lordships can strike down that provision, and thereafter it would be open for them to create a waqf. Lord, I am posing a question to myself. It is so egregiously or, my lord, so my lord, arbitrarily ex facie illegal and unconstitutional, not only illegal, my lord, that it needs to be stayed today. Lord, next judgment, para 7, Lord, so-and-so versus State of Karnataka. The prohibition from alienation is to effectuate the constitutional policy of economic empowerment under Article 14, 21, 38, 39, and 46, read with preamble of the Constitution. Accordingly, it was held that refusal to permit alienation is to effectuate the constitutional policy. The alienation was declared to be void under Section 23 of the Contract Act, being violative of constitutional scheme of economic empowerment to accord equality of status, dignity of persons, and economic empowerment. Now, my lords, may kindly see. Under the scheme of the Constitution, the scheduled tribes as a class require special protection against the exploitation. The very existence of scheduled tribes as a distinctive class and the preservation of their culture and way of life based as it is upon agriculture, which is inextricably linked with ownership of land, require preventing an invasion upon their lands. The impugned act and similar measures undertaken by the different states placing restrictions on transfer of lands by members of scheduled caste and scheduled tribes are aimed at the state policy enshrined in Article 46 of the Constitution, which enjoins that the state shall promote with special care the educational and economic interest of weaker sections of the people, and in particular of the scheduled caste and tribes, and shall protect them from social injustice and all forms of exploitation. One has only to look at the artlessness, the total lack of guile, the ignorance and the innocence of helplessness, the economic and educational backwardness of the tribals, pitted against the artful, usurious, greedy land grabber and exploiter invading the tribal area from outside to realize the urgency of the need for special protection for tribals if they are to survive and to enjoy the benefits of belonging to sovereign, socialist, secular, democratic republic. My lord, kindly appreciate if there is a state restriction, and there are many states where there is a restriction.
Maharashtra also is there.
Maharashtra has, Gujarat has, my lord, all are upheld by the court.
One of the cases is from Maharashtra only.
Yeah, yes. Now, my lord, kindly appreciate, I am appealing to your lordship's conscience. I am unable to go and purchase the land of the tribal because the state law prohibits. I go there, ask him to create a waqf. And I become the mutawalli and do whatever I want to do with the land, my lord, in question. This can be, my lord, a misuse. I'm aware, my lord, a possibility of misuse cannot be a ground for challenge, but cannot be a ground, my lord, can be a ground for upholding that this is the mischief which the statute seeks to protect. And ultimately, your lordships can always strike it down. My lord, please, my lord, bear in mind while reading every section, whether this section is so atrociously unconstitutional on the first blush that it needs to be stayed. That's, my lord, my limited purpose, my lord, right now. Then kindly come to, my lord, next 104. Application of Act. My lord, this is deleted and the deletion is challenged. My lord, section 104. My lord, your lordship would find in my note. My lord, I'm sorry, it's not paginated.
Just very.
Para 11. Para 11. No, just for your lordship's ready reference. Yesterday, my lord, I was taking your lordships to two different documents. My lord, I don't wish to do that today. So 104. Application of Act to properties given or donated by persons not professing Islam for support of certain waqf. Lord, I need not read. Non-Muslims were permitted to create a waqf. Lord, that happened by way of an amendment in 2013, as I pointed out on yesterday. In November 2013, this was brought in. Now, please recollect the statement of objects and reasons of 1923 Act, where in 1923, in detail, they said that this is being used to defraud the creditors. I am a Hindu. I know waqf is an Islamic concept. By virtue of 104, I would create a waqf on my property. My learned senior, my lord, who is supposed to recover money from me and who has a decree in his favor against me, cannot execute the decree the moment I make a waqf of my property. But the JPC has given a very plausible and very, very convincing ground. Look, this, Lord, kindly mark this. This does not deprive a non-Muslim to donate for any waqf. Look, creating a waqf is different from donating to a waqf. Lord, please see what the Joint Parliamentary Committee says at the foot. Lord, it ultimately says, my lord, I'm not reading. And this is why, my lord, 5 years. This is why 5 years. That if you are a if you have to show that I am a Muslim, how is it is to be shown, I'll show. And for 5 years, so that you don't use this device of waqf for the purpose of defrauding anyone. And that is the menace, my lord, accepted 102 years back, and that menace continues. But now, my lord, I am a Hindu. I cannot create a waqf because 104 is deleted, but I still want to donate. Well, I can still donate. Please see section 72. That is what the JPC says, that if you really have a faith in a particular waqf, then donate it. Would your lordship see section 72, 1, Roman 5, F?
Yes.
Lord, this is regarding annual contribution payable by the waqf and what should be the income. But I'm not reading the whole. It's a very long section, but please see Roman 5. Your lordship gets, my lord, the Chief Justice gets.
Yes, sale proceeds.
Sale proceeds of immovable properties or rights relating to or arising out of immovable properties, if such proceeds are reinvested to earn income, provided that following items of receipts shall not be deemed to be income for the purpose of this section. Please see F. Donations in cash or kind or offerings made by the donors as contribution to the corpus of the waqf. I am a Hindu, I am a non-Muslim, I can donate to the waqf. I cannot create a waqf. Well, that's the only limited thing, my lord, which has happened.
It means that no immovable property can be donated, actually.
It can be donated also.
No, but how will it cover here? It only says with regard to cash or kind
Donations in cash or kind,
or offerings.
or then it becomes a waqf. But my lord, how, my lord, can anyone object to a provision that waqf, which is an Islamic concept, though not an essential religious practice, should mandatorily be permitted to non-Muslims also?
No, it can't be mandatory. It can always be voluntary.
My lord, if I am a,
It can only be voluntary.
my lord, I am a Hindu, my lord, I am a Hindu.
2013 when this was brought.
Pardon?
What is the SOR of the 2013 Amendment Act, which brings this 104?
No, 104 was in 95 also.
95, no, the footnote says that it is brought in 2013.
Just let me check up. Lord, yes, Lord, I'm sorry. Lord, kindly see 95.
Of course.
It was brought in 2013 and removed in 2025 now.
Yes, Lord, because 2013 up to 1923 till 2013. My Lord Justice Masih, my Lord, just listen to me, Lord. Up to from 1923 till 2013, the qualification was any Muslim can create a waqf. In 2013, any Muslim was deleted and any person was substituted in 13 after 90 years. Lord, that is now done away with. That it has to be by Muslim. If I am a Hindu.
All through it was limited to one religion.
Yes. And
a person professing Islam.
Correct, my Lord. My Lord, kindly see. Lord, if I am a Hindu, I really want to create a waqf, which is now not permissible. I'll create a trust, my Lord, for the same function. Lord, can I not, as a Hindu, create a mosque and run it as a public charitable trust? It's not that the charity is prohibited. Charity of a particular kind is prohibited. Now, my Lord, kindly see the next provision.
You were yesterday saying that some provision which was introduced in 1995 was deleted in 2013.
Yes. So 2013 also, yes. Section 87, my Lord, for example, was deleted. And Section 36, my Lord, was amended that from 2023, 90 years, Muslim can create a waqf. In 2013, only person were deleted and any person came. Now, 95 brought, the Lordships would recall the 3-member committee.
Yes.
Sayyid Ahmad.
76.
They said that
Not to interrupt, 2010, there's a judgment of this court saying that a non-Muslim can create a trust. That's why 2013 amendment came. 2010, there's a judgment of this court by Justice Singhvi saying that non-Muslims can create a trust. Anyway, I don't want to.
Lord, I don't wish to go into it. There is also, my Lord, a provision which is taken care of. But ultimately, my Lord, your Lordships would examine whether that needs to be stayed right. When he has another remedy, a Hindu who wants to really create a mosque, he can create a mosque and run it as a public charitable trust. Why should he create a waqf only? My Lord, 87 was deleted. My Lord, apropos, my Lord, the Chief Justice's query, your Lordships would recall in 1976, the committee was appointed, 3-member committee.
Their malpractice and all that.
Yes, my Lord. And they said that there is a rampant mischief by creating waqf and not getting it registered. We must do something harsh. So they suggested an amendment that you provide for a statutory mechanism that if you are not registered, you can go to the court of law. Parliament in 1984 passed that act.
But it was not.
It was not implemented.
It was not notified.
Notified. Now in 95, that came as Section 87. Just to ensure that only registered, that mischief which was pointed out by Sayyid Ahmad committee is remedied. And he was very harsh, my Lord, in use of the language in report. page 53 is that provision, section 87 of my reply.
Yes.
Lord, this was deleted in 2013.
Page?
Lord, 53 of my reply. Page 53 of my reply. Lord, this came in 1995, but surprisingly deleted in 2013, November 2013. And I must, Lord, add here, I mentioned it yesterday, this kind of provision that unregistered trusts or entities will not be able to litigate is found in all trust laws, whether private trust or a public charitable trust. This is not something novel for Waqf, but deleted. Yes. It was, my lord, a copy paste of section 31 of the Bombay Public Trust Act. Now, my lord, another
Copy paste of which?
section 31 of Bombay Public Trust Act. Lord, page 35 of the counter, the committee itself records, the Syed Ahmed committee. Page 35, my lord, if your lordships can have only, my lord, for a second, of my counter, my lord. I have quoted, my lord, page 35 of my counter, the committee's report, committee headed by, my lord, Syed Ahmed.
Page 30.
Somewhere in the let me read, my lord. Deliberate concealing of Waqf and willful failure to have them registered is a deeply prevalent malady affecting the administration of Waqf. Attaching highest importance of this matter, we have separately provided for imprisonment, etc. Please come. We consider that in the implementation of this policy, we have a very
You already read that.
Yes. So this was taken from Lord and every trust act has this provision. There is nothing wrong about this. Now, my lord, next, which was under attack was Limitation Act. Earlier, Limitation Act was not applicable. Either for the trust or against the trust. So it worked both ways.
Till 2025.
25. So we said now Limitation Act would apply. So if I have to file a suit against the trust, against the Waqf, I'll also have to go by the Limitation Act. And if Waqf wants to file some proceedings against me, say for my eviction, suppose I'm an unauthorized encroacher in the Waqf property, they will also have to file, my lord, within limitation period. The question is, my lord, when Limitation Act is made applicable, which is applicable to rest of the country, Lord, I'm posing a question to myself, would it be a good enough ground to stay it at this stage? I leave it at that, Lord, there's nothing more. Then 107, I'm sorry, 108. Lord, 108 is evacuate property. Lord, my preliminary problem and the preliminary objection is this. Lord, we are arguing on academic challenges. My lord, what is evacuate property? My lords are aware. During, at the time of independence, when partition took place.
Regarding tribals also, your argument is the same.
Yes.
None of the tribals has come to the court.
Yes, but not to my knowledge, but maybe they may have chosen one or two tribals.
It is a tribal area.
No. Its entirety is not, fortunately. Anyway, my lord, it's for their protection. If one person does not like it, he doesn't represent entire tribal community in the world. My lord, kindly see the difficulty.
Sorry, your lordship has asked a question. I don't wish to interrupt.
But you are still doing it.
No, my lord asked a question.
But not to you.
Very well, I'll.
Anyway.
We asked whether there is any.
No, anyway, I was just joking, my lord. We always do that. I don't want to interrupt, but then we end up.
Get back to the old Ahmedabad days.
Yes.
My lord, there are petitions from tribal areas espousing this particular cause. That's the simple answer. So, my lords, my learned friend may not be correctly instructed when he says that there are no such petitions.
Lord, I must tell your lordships now, my lord, I didn't want to say this. There are petitions by tribal organizations defending this provision that we are being victimized.
I am representing one of them.
Yes. That we are being victimized, our lands are being grabbed under the garb of Waqf. Therefore, my lord, I am respectfully urging that there is view and a counter view, but it is not so, my lord, atrociously unconstitutional.
No, agree that.
That it has to be stayed here and now.
What is that?
Yes. My lord, another last, my lord, was the evacuee property. Lord, evacuee property. Evacuee property is a property which was left in India when people fled to Pakistan. Correct, my lords? Those properties prior to, my lord, that partition, which were Waqf, custodian. Lord, that Evacuee Property Act itself is repealed now. So corresponding provision is repealed, my lord. But we do, at least to my knowledge, there is nobody who is here saying that this was my evacuee property, because of deletion I am facing this problem. Otherwise, I can deal with that. Which is that evacuee property? Where is it situated? What is your problem? What were the difficulties faced by you?
Your half an hour is.
My lord, it's over, my lord, and my arguments are also over. Give me only 5 minutes. Lord, I don't, Lord, only one thing. Lord, kindly take Sharia Act. Lord, on the argument, I don't wish to enter into this argument for the simple reason. Now, earlier, my lord, from 2023, a person has to be Muslim. Nobody objected to it till 2013. Now it says person has to be Muslim practicing for 5 years. I have given the rationale. They can wait, my lord, if they, or they can prove. The rules will come. And maybe, my lord, it would be that you give a declaration before some authorized person that I am practicing Islam, etc. But please have a look, my lord. If I want to use Sharia Act and be governed by the personal law, I have to prove that I am Muslim. My lord, we don't have, my lord, any other personal law because they are codified for other religions. But for this, please see section 3, Sharia Act. Sharia Act is applicable as a personal law to all Muslims. Please see section 2. Section 2, personal law of marriage, dissolution of marriage, talaq, ila, zihar, lian, khula, mubarat, maintenance, dawa, so and so. In cases where the parties are Muslims, shall be Muslim personal law, Sharia. Your lordship gets my last line. Now please see 3. Any person who satisfies the prescribed authority that he is a Muslim and that he is competent to contract within the meaning of section 11, that he is a resident in territory so and so, may by declaration in the prescribed form and filed before the prescribed authority declare that he desires to obtain the benefit of provisions of this section, and thereafter the provisions of section 2 shall apply to the declarant. Lord, if as a Muslim I have to go to a prescribed authority for getting benefit of personal law in case of marriage, divorce, etc., etc., so the same thing is for Waqf, which was there, my lord, since 1923. Now only additional condition is 5 years. 5 years because you don't defeat somebody's rightful claims by creating a Waqf. Lord, my last submission, my lord, as I have said, my lord, I have many judgments, my lord, on the question whether it is an essential religious practice or not. But that being a pure constitutional question, I have cited some judgments, my lord. Lord, I have Shirur Mat, I have Tilkayat Ji, my lord. There are a large number of 5-judge and 7-judge judgments. But I'm not, my lord, citing it right now. Last point, Lord, there are some petitions. There were some petitions. I'm making my position clear. I don't represent them. Where they have challenged the main act, 95 Act. What is under challenge is the amendment to 95.
Hari Vishnu Jain.
No, my lord, there are several.
Vishnu Shankar Jain.
Vishnu Shankar Ji. But there are several petitions. Lord,
And in 2025, they want us to take the provisions of 1995.
I'm saying something different. I'm not supporting them. I'm neither opposing them. I'm not supporting them. I'm saying something totally different. Lord, their argument was,
We will not listen to.
no. I'm not on the stage.
We are not going to entertain any petition in 2025 challenging
Allow me to
1995.
allow me to come. I'm saying something totally different.
Yes.
Their argument was that since we were sent to High Court, these people also should be sent to High Court. I am not raising that plea. It is a question of law. It is a constitutional question. I am not raising that plea. Please hear the matter under 32. That was I was saying. I was not supporting them. It was their case that if we were sent to High Court, send them also to High Court. I'm saying, please hear it. But
one bench having handed in the matter, how can we even hear that?
Absolutely.
Let us
But
continue.
I'm not raising that. I'm making it clear that I'm not raising it. And Lord, therefore, your lordships may hear it at any date of your lordship's convenience. But Lord, rarest of the rare thing, my lord, they have not crossed the threshold, my lord. Last, Lord, frequently without reading Ram Janmabhoomi judgment, my lord, they have said that Waqf by user is accepted. Lord, the entire judgment says that under the act as it existed, it's a 2019 judgment, 2019 or 20 judgment, that as it existed, Waqf by user was there in the act. So they say Waqf by user is a recognized concept. But I am also not disputing Waqf by user was a recognized concept. It is now deleted. So it never said that it was an essential religious practice or something. They said Waqf by user is an accepted practice. It was an accepted practice. It was statutorily recognized practice. And statutorily recognized practice can be statutorily taken away. Now, my lord, if your lordships were to stay that, something which is taken away by operation of law will, by an interim order, come back, Lord, which your lordships would not do. So that's my respectful submission.
Thank you.
But grateful for a very patient hearing.